Greetings, salutations, and welcome to the inaugural episode of the Wage and Hour Minute Clinic with myself, Rob Pepple, ESQ, and my main man, Gus here. Through a short series of videos, we will try to untangle the complicated web that is California wage and hour laws that plague employers, but that try to guarantee employees a fair wage and a fair time at work. So if you'll stick with me, we'll do our best to untangle some of those webs, try to make you a little more compliant, and try to make the workplace a little better for everybody else. But first, a legal disclaimer. This video is for informational purposes only. Watching the video does not create an attorney-client relationship, and the information herein may not apply and should not be relied upon in your specific situation. Further, we cannot guarantee the accuracy or completeness of the information due to the ever-changing legal landscape. So sit back, enjoy the show, and remember to consult with a licensed attorney about your specific situation. Now let's get into what we're going to cover today. California meal breaks. We're going to talk about how many, when to start, how free is duty-free, record keeping, and more. How are we doing over here, buddy? We doing good? My legal assistant. First, let's talk about how many meal breaks you get in a day. You can have up to 2. And the way it works is the amount of time that you work, that's what equals the entitlement. So, for example, if you work from 0 up to 5 hours, you don't get entitled to a meal break until you've crossed that 5-hour threshold. Once you cross the 5-hour threshold, you're entitled to 1 meal break. Now, once you've worked 10 full hours, you're almost entitled to a second meal break, but again, you have to cross that 10-hour threshold to be entitled to up to 2 meal breaks. Employees who work less than 5 hours, or up to 5 hours exactly, may not be entitled to a meal break. So when do we start meal breaks? This is commonly called the 5-hour rule. The 5-hour rule states that an employee must be given the opportunity to take a duty-free, uninterrupted meal break before the end of the 5th hour of work. So what does that mean? Let's say that you started at 2 p.m. Okay, that means before 5 hours have elapsed, remember the first hour starts at 0, you must start that meal break. So that means your meal break must begin before the end of the 4th hour, 59 minutes and 59 seconds. In this situation, okay, from 2 plus 5 is 7, but you'd have to start that meal break at 6:59:59 to be compliant. And again, details matter in this area of law. So you can have up to 2 meal breaks in a day. But the question is, how does those 5-hour rules play together? Back in 2012, it was unclear whether or not there would be a rolling 5-hour rule, meaning every 5 hours an employee gets a break, or whether or not you had to work actually 10 full hours to get that break. Well, the Supreme Court in 2012 answered that question for us. It's not a rolling 5-hour period, but rather a mathematical one. So if you were to really take it up to the limit and work a full 5 hours, your second meal break wouldn't begin until you had another 5 hours of work. Or for example, if you took a meal break at 4 hours, right, then you would have to work 6 hours to get up to that 10 threshold. So that's important to remember. So for employers who are trying to comply and having those meal breaks come early, they can work those employees a little bit longer in the afternoon in order to kind of catch up for that meal break time in the end. So the point is, 10 hours is mathematical, not rolling. Now, how free is duty-free? Boy in a bubble. I mean it. California does not joke around when it comes to not allowing employees to be bugged, disturbed, or working during their breaks. And the way we see employers typically get involved with this is having managers text or call employees during their breaks. Obviously, working during breaks is wrong. Or even having customers come up to them and bother them during their breaks, ask them questions. Now, to be quite clear, employees can choose to work during their breaks. It's their time. However, practically speaking, you're not going to want to allow that, because what's going to happen is those employees, especially some of those go-getters who tend to work through breaks and tend to do, work during breaks and to allow customers to talk to them, what will end up happening is when you eventually separate this employee, we all know that people get separated on a daily basis. That employee will probably turn around and saying that it was the nature of the work or that you forced them to work through that break. So again, remember, boy in a bubble or girl in a bubble or they in a bubble. So how long and what does net mean? So net does not appear in the statute. However, it is an important concept. California law requires employers to provide 30 minutes of rest time. And over the course of evolution, we've learned that really that involves 30 minutes of pure rest and relaxation time. Well, maybe not relaxation. But the point is when an employee finishes work, if they have to egress or leave the workstation to get to the break area, that time probably shouldn't be counted. So we talk about adding walking time. And probably one of the best practices out there is just to provide 35-minute meal breaks. And again, these can be unpaid. So record keeping, this is extremely important. So California law requires employers to keep records of accurate time worked. And the way that translates into meal breaks is because meal breaks are not worked time. You have to record the start and end of them, and you have to be very exact. In 2021, we had a court case come down that was very clear on that. So where do we see employers get messed up? Here, you have handwritten timesheets and you have very even times that don't vary from day to day. Now, that doesn't happen in real life. No one starts every single day at 9, clocks out at 1, right back at 1:35. There's that 35-minute rest break I recommend, and then clocks out evenly. What ends up happening more often is that people start work at a minute past. Take their meal break, at 3 past. These types of detailed minute-to-minute punch records are the type of things that you're going to want to look for because California courts are rather draconian about pushing the burden onto employers when they have bad records. And what I mean by that is if you have records that show the absence of a meal period or show a late meal period, the burden of persuasion in court, which typically belongs to the plaintiff, will fall to you. And you can probably imagine without good records, and perhaps not even your own managers are still employed anymore, the ability to prove that someone had the opportunity to take a meal break 3 years ago is rather difficult. So again, accurate records are incredibly important. Have a written policy, okay? That's it. Have a written policy, but make sure it's accurate, and then make sure you train your employees on it. What we see in these cases all the time is employers that have these perfect written policies, but they don't really train on it and they don't really enforce it. So again, find a qualified attorney, get a good written policy, and train your employees on it. Make sure they know, and discipline when employees break those rules. So there are some nuances we're not going to cover today, but they will be covered in another video. First, we're going to talk about meal waivers. And the upshot of that is that employees can voluntarily waive their first meal if they work more than 5 but less than 6. And so they're going to waive a second meal break if they work more than 10 but less than 12. They can actually waive them if they work exactly 6 and exactly 12, but again, you don't want to push that last second. Also, there are such things on-duty meal break agreements. Don't mess with them. They're incredibly hard to get right. And of course, there are collective bargaining agreement implications. If you are part of a union or you have a union, some of these rules can be tinkered with, but they can't be broken. So what happens if you screw up? Here are the penalties. You get a maximum of 1 meal break penalty per day, no matter how many meal breaks you screw up. So for us, that would be 2. So if you have 2 bad meal breaks, you get 1 meal premium paid to that employee. It's at the regular rate of compensation. Now there was a bunch of fighting about this for the past 2 or 3 years about whether or not that regular rate of compensation means that base hourly rate you pay people, or does it mean something else? And it turns out it means something else. It means a lot what it means for the overtime rate of pay. And for those of you that are hearing for the first time that overtime isn't just the hourly rate, let's watch the next video I put together on that. The point is, your meal break premiums have to be paid at a rate that takes into account all includable compensation. Includable compensation can be commissions, it can be bonuses, it can be any number of things. Fringe benefits, PTO, vacation, that type of stuff stays out. But generally speaking, the regular rate of compensation, or overtime, the regular rate of pay, will be more than the hourly rate. And if you don't pay that extra, it's tantamount to not paying wages. And as you'll learn in later videos, California law punishes a non-payment of wages 3, 4, sometimes even 5 times. So you don't want to do it. And finally, it has to be listed on the pay stub. Because these are wages and because these are they're not hours worked, but because they are a rate of pay, they do have to be listed under your pay stub and they have to be accurate. And failure to list those could end up in derivative penalties being assessed against your company. So that's about it for today. Until next time, right? This is me, Rob Peppel, ESQ, and I want to thank you for tuning in to this inaugural episode where we help save employers millions and promote fair treatment of California workers. When it comes to meal breaks, remember to provide, enforce, and record those breaks or you might pay the price later. And remember, stay compliant, stay profitable, and be good to your workers, and they'll be good to you. Have a good one.